Hi, my name is attorney Ed Malek. I work as a lawyer with Malek and Malek. I've been here practicing law since 1972, and I'd like to discuss a little bit about my feelings about insurance and the insurance industry. Formerly, I'd worked as a insurance adjuster, claims adjuster for an insurance company here in Columbus, Ohio, having transferred from Cleveland. And thereafter, after I obtained my law degree, I left the insurance company and subsequently went through the prosecutor's office and then into private practice myself. But the insurance industry has taken a general road to what I would say was collapse on behalf of the injured person, our citizens, and the injured person they're supposed to be serving, and as well as their insured policyholder. Previously, the insurance company tried to understand where the person's coming, the psychological makeup, the heartache the injury had provided to them. But nowadays, they are solely working on the number of bills, an algorithm they're using to evaluate cases. My suggestion on a very serious case that one provides the extent of injury to the insurance company, makes a claim for policy limits or whatever the attorney feels available, and then lets the insurance company respond and not engage in continued negotiations on a very serious case. In those cases, I would recommend that the attorney commence litigation as soon as possible, because this seems to be the only way that the insurance companies tend to understand the seriousness of cases. They want to see the attorneys willing to go to court, willing to file a lawsuit, and willing to pursue the lawsuit against them. If it's a minor type of injury, say a chiropractic type of sort of injury, I would encourage the injured person, to obtain sufficient treatment to the extent that the injury justifies. And I don't mean going once or twice, I mean treating the injury to its ultimate satisfaction. In these events, in these minor cases, soft tissue cases, the insurance company will look at the amount of medical bills and pay a little bit more, maybe $1,000 or $2,000 more than the medical bills, and count on the chiropractor to negotiate his fee downwards to enable the attorney and the client, particularly the client, to receive a favorable or fair amount. But this doesn't mean that that client, the injured person, is going to get a substantial amount of recovery. But to really effectively prove to the insurance company, you have to file your lawsuit after providing documentation to them why they should pay the full amount of policy limits, or a substantial amount of the policy limits of the offending tortfeasor. Insurance companies are not there to benefit the injured people, the injured citizens of the state of Ohio, which is why I've written to the State of Ohio Department of Insurance on numerous times to explain how unfair they are to the citizens of the state of Ohio, the driving public, and those people that have been injured, that have families in Ohio, that must provide for them and care for them for the rest of their lives. But that has been ineffective to a certain extent. Occasionally, I've reached out to senators to get involved, and occasionally they have on behalf of our clients. Also, the policyholder completes a contract of insurance. The policyholder wants the injured person to be taken care of as well. They want a fair settlement to be made so they don't become engaged in litigation. But and any type of unfairness, low evaluations by insurance companies is in fact compelling the policyholder to effectively defend a lawsuit, which they don't want to do either. Now, how are the insurance companies evaluating cases? I think there's been many explanations of this. In Ohio differs a lot from West Virginia. Some states, uh, New York, also up in Ohio in the Cuyahoga County area, where the jurors in those areas, West Virginia, state of West Virginia, uh, near to West Virginia, they have been states in which the state laws regard the rights of the injured person extremely well. Cuyahoga County, because of the jury's makeup, they identify with the injured person. They aren't normally employed by insurance companies, the jurors, and they effectively take the side of the injured worker and can identify with them. So that's what it's all about, treating people fairly and treating people rightfully and fairly for injuries that may be with them for the balance of their life and will at least affect them in some way. Going back, how do the insurance companies value cases? Insurance companies take the bills and the IC9 codes and the codes of the injuries, and they plug that into their computer. And based upon the bills, as if they're really related to the injury and not unrelated, and the IC9 codes, the extent of injury, they will determine through their algorithms what the amount of what the adjuster is authorized to pay. And now the adjuster is controlled by the Aetnas or the Progresses or the Geicos or the American Family protocol in their companies. And their whole object is to make money for the corporation. It's not to make money or pay people fairly, it's to make money. Hopefully, they will be fair also. But their ideas of fairness are far lower than what is normal, that you and I consider to be fair and normal in our society. So they plug the IC9 codes and the extent of injuries into their computers and the algorithms and the amount of medical bills, and they come up with an offer. And the offer basically is only maybe $2,000 more, maybe $3,000, maybe you can get them $4,000 more than the bills. It's oftentimes not that much. And they will explain to you ad infinitum, the adjuster, and the adjuster is a good person working for a living, wants to keep their job, and they have to fit within this format as designated by management. So they'll make that offer, and you'll be fighting them up to get another $1,000, another $500, and you can take weeks and months sometimes to do that. So sometimes it's best to accept the monies and work the case up to as much as you can if it's not a long-lasting injury, but if it is, I really believe that you should get an attorney that will file a lawsuit in that particular case. And the attorney can tell you pretty quickly whether or not surgery is involved. That should be a lawsuit case, or at least an effort to try to get the insurance company to pay policy limits and then filing the lawsuit. It's unfortunate that we have to work in these scenarios in Ohio. The state of Ohio, unfortunately, favors corporations. The legislature is receiving monies for their campaigns and favors the people, the legislatures who support big business. They don't support the small guy like they do in West Virginia, and even in Cuyahoga County, or our portion of our state close to West Virginia, is benefits, and their juries benefits the work of the injured person more so, in Cuyahoga County as well, but not vastly in the rural areas of our state. So please vote, but please understand corporations are only interested in their own well-being and the bottom line, not you, not me, not the policyholder, but their amount of money they can make for their corporations and the higher level corporate managers and presidents. Thank you very much, and I'm sorry to be so stake these statements as it is. My feelings are exactly what I've told you. Thank you very much.